cites Gonzalez versus State, 627, subsecond, page 63, Florida 2nd DCA, 1993, as providing for some additional polling if the court feels it to be appropriate. So I intend to, first thing on Monday, as a housekeeping matter, just poll the jury and say, is your verdict finding the defendant guilty of first-degree murder and not second-degree murder, yes or no? I'm putting that out there to everybody to let you know, so it won't throw you a curveball Monday morning. Anybody have any objection to that?
Judge, could you be so kind as to scroll up? Was that the same issue on count 2?
Oh, on count 2?
Yeah.
Well, you want me to pull up the count 2? Yeah, they did the exact same thing on the count 2 verdict.
I just wanted to see it.
Yeah, let me bring that up for you. That's count 2.
I know it's been scanned. I'll print off a copy of this.
Right, okay. Anybody have any objection to that additional polling?
No.
Okay. All right, and then once we do that, I will give the jury the preliminary instruction for the penalty phase. Print it out somewhere. It currently is instruction 7.10. Up until a few weeks ago, I think it was 7.11, but now it's 7.10. It's the preliminary instruction. There's little to change in there, the he's and the she's, and there's an option on the front end, depending on whether it's the same jury that found the defendant guilty of murder or whether it's a different jury handling the penalty phase. Obviously, the option for the same jury will be exercised, and there are 2 counts of murder in the first degree. The standard instruction 710 leaves a little blank as to how many counts of first degree murder that there were. So I'll give the jury that instruction first off. Then you all will do your opening statements, evidence and testimony, and then unlike the guilt phase, I will give the final instructions after the closing arguments rather than prior to the closing arguments as provided for in Florida Supreme Court standard instructions. Before we get into the matters that were taken up this morning, let me ask you all from the state's perspective, how long do you anticipate that your case is going to take in the, your case in chief in the penalty phase?
The case in chief will be very, very short, Your Honor. I think all we have to present really are victim impact statements. I think the majority of our evidence as to the aggravating circumstances has really been already presented during the guilt phase of the trial.
How long do you anticipate on the victim impact statements? And I want to talk about that this morning too.
I can't imagine it being more than 30 minutes to an hour, if that long. I think we're going to be presenting 4 statements, so however long it takes to read 4 statements, approximately 2 pages each.
All right. And from the defense perspective, you have a couple of experts. There's an issue on one of them we take up this morning, but assuming everything's admissible, how long do you think your case will take?
Well, for Monday, after opening statements, it's our plan, and I need to talk again with Ms. Jordan. I think we've got lined up, I know we have 2 experts lined up, Dr. Mills and Dr. Quiroga. One in the morning, Mills will be is scheduled for the morning, but we have them available all day. And then Dr. Quiroga won't be available until the afternoon. We have, I believe, 8, maybe 7 lay witnesses lined up as well for Monday. And I'm going to touch base again with our team to finalize that. And then we'll probably have 3 lay witnesses plus Dr. Buffington for Tuesday morning. I believe that will be done by noon on Tuesday at the latest. And just kind of as an aside, it's been my experience, and I know every case is different, but when you call lay witnesses, if everything goes well, usually they don't take as long as a regular witness in a guilt phase, just because typically cross-examination is not lengthy, if at all. So those may go quicker than you would see in a guilt phase. That may, depending on the availability of a couple of witnesses I have in mind, may mean that we may be done a little early on Monday. But I'm going to see if I can have some maybe backup to try to make sure that we utilize as much of Monday as we possibly can. It's hard to always predict these things, but it's just based on experience. I know that Dr. Buckner is not available till Tuesday morning, so that's kind of the outline of the proposed schedule. And then Tuesday afternoon, we should, if the state has any witnesses, they can call.
So you're planning on being done with your case in chief on mitigation by Tuesday lunchtime?
Yes, sir.
If all goes according to plan?
Yes, sir.
It's okay. All right, let me ask the state on your rebuttal, if there's going to be a rebuttal, how long do you anticipate that would take?
There will be, Judge. We have 3 experts lined up for that. We've instructed them based on what we thought, the timeline for the defense's presentation of their case. We told them we probably thought we would need them either Tuesday or Wednesday, so it sounds like our predictions on that was roughly accurate based on Mr. Wood's representation this morning. So we have Dr. Goldberger, University of Florida, Dr. Danziger, and Dr. Meadows, who we can address in a few minutes. We have lined up to do a evaluation tomorrow at 1 o'clock. So he'll be potentially prepared, depending on what the results are of his evaluation of the defendant tomorrow. So we will have him lined up as well. And then we have Judge Tinlin. We have him on our witness list as rebuttal as well.
I presume Judge Tinlin wouldn't take very long, although us judges can't be talking at times. Assuming you call all those witnesses, how long do you think that would take? Is that a half day if we started that in the afternoon?
I think so. I mean, I know Mr. Wood was talking about lay witnesses, but the expert witnesses, obviously, those will tend to be a little bit longer because it's just not only direct, but I would anticipate a good amount of cross for all these doctors. So I do know that I have to get them done by Wednesday because at least Dr. Goldberger, I think, is not available Thursday. So
Well, it sure sounds like we could easily get done by Wednesday. I'm wondering if we could be done by Tuesday if all goes according to schedule.
It's
But I
certainly
don't think I've had too many cases that have not according to schedule. Rarely do they.
it's certainly possible. Obviously, one of the difficulties is that when you bring a doctor and they don't testify and they have to come back the next day, it obviously costs a lot more money.
Yes, it does.
So they're charging by the hour. We're going to do our best to try to get it done as quickly as possible with that sort of caveat, Judge.
Okay, well, I appreciate the schedule. As for your closing arguments, I'm not going to hold you to any of these times, but I'm just trying to get a feel for scheduling. How long do you anticipate your closing arguments might take? I'll ask the state first.
Well, we don't have 7 counts to argue, so I don't know that it would take as long, but knowing that Your Honor gives us the option of picking our times and then holding us to it, I'd probably ask at the same time that Ms. Dunn gave, just so, but I don't think it will take that long. So.
And she didn't use all of her time, but
Correct.
that was an hour and a half. Mr. Wood, I know from the defense perspective, these things are quite different when you get into a penalty phase. Just ballpark, and I'm not going to hold you to these numbers at all. We'll talk about this as we get closer, but just ballpark. We're trying to get a feel for schedule.
Hour and a half, 2 hours at most.
Okay. So there's a chance we could get this to the jury Wednesday. Again, we have the same sequester issues. We'll have to prepare for that, but more likely Thursday morning to the jury, but we'll see how it goes. All right, thanks for the scheduling update.
Sure.
Let's talk about some of the motions that we have pending. There's a handful of motions. You can take them up in any order you desire.
Why don't we talk about the jury instructions?
Okay.
I filed some initial objections.
I know I saw that
Should be Wednesday night. I made the mistake of staying alert and attentive to the issues of this case rather than going to some other, right?
you cut and pasted.
Actually, I did and did not. I did and did not. There's occasionally we have initial creative thoughts on things, but Just in terms of background, and I think you probably know this because you actually talked about it briefly during the course of the case. When these jury instructions first came out from the Florida Supreme Court in 2017, before they became official, the Florida Supreme Court asked for commentary from various groups. Two of those groups were from, or at least two that submitted comments, among others, were the Florida Public Defenders Association and also the Judicial College, I don't know the official name of the Judicial College for death penalty training that you folks, the judges go
It
through.
was the faculty for the handling capital cases course.
Yes, sir.
And the Judge Hankinson and Judge Colley, I think, submitted the material.
And I saw the letterhead was from the 12th Judicial Circuit that was submitted. So what I did was, when I then saw what the original, 2017 jury instructions looked like, and in those two comments or commentaries that were sent into the Florida Supreme Court had outlined a number of different objections, requests for redactions and additions, that sort of thing, which were fairly extensive. And then when the Florida Supreme Court revised their jury instructions in May of this year, most of, ironically or helpfully, most of the requested redactions, objections from both camps that I cited were eliminated in the most recent revisions. That's why the edits that I've contained in my objections are not as numerous or not as intricate as they would have otherwise been.
Right.
So that's the backstory of why my objections look the way they do.
When I went through this last year, which I think was probably the first or one of the first death penalty cases being tried in the state after the new statute went into effect, the Supreme Court had just come out with its interim instructions that it was telling everybody to use. Prior to us getting to the penalty phase in that case last year, the Supreme Court opened it up for comments, and Mr. Warren, who was defense counsel on that case last year, submitted all of the comments that, and you can imagine it was like us people all over the state submitting comments, but now we have a final set from the Supreme Court effective May of this year, but I do appreciate what you have submitted here.
One additional thing, Judge, too, that when I was rereading this morning, to be consistent with it has to do with the definition of premeditation. As you may recall, we had objected to premeditation for the standard jury instructions for guilt phase. I'm going to, probably by the end of business today, to make sure the record is clear on that, I'm going to propose that same instruction be, for the definition of premeditation, be included in this. I just wanted to let the court know that is going to be something I'm going to put on the record in a separate pleading, but for the purpose of today's argument, we are going to be requesting that same premeditation definition be included rather than the standard premeditation instruction for the cold calculated premeditated aggravating factor that is being requested by the
And
state.
I'll look at that when you submit that. It is fully my intention to give these standard Supreme Court instructions as promulgated by the Florida Supreme Court at the end of May of this year. They call for not deviating unless there is a compelling reason or an issue that comes up that would call for deviating. And we haven't gone through the proceedings yet, so I'm just going to tell you what my intention is at this point, but when we have our final charge conference, I'll hear anything. Maybe there's something that comes up that will call for a deviation, and I'll address that at that time.
Do you want to then maybe table this until that time, so I'll file the supplemental pleading regarding premeditation, or would you like to address it now?
Let's go ahead and table it. I'll take it under advisement because I'm not having my final charge conference.
Yes, sir.
I'm having a preliminary charge conference at this point. I don't want to tell you that I'm not going to give anything that you're asking for, but I do want to make it known to everybody it is my intention to give these standard instructions promulgated by the Florida Supreme Court.
And for the record also, too, the state has emailed me their proposed death penalty instructions, both preliminary and final, yesterday. And but we'll deal with that at the charge conference and follow up with that.
Okay. Was there a preliminary?
There wasn't.
Okay.
I was just about to.
See.
I don't need, do I need to do that, Your Honor, or no,
No.
that's something you do?
Okay.
Okay. And the verdict forms as well had been submitted.
Right. Let's preliminarily talk about the instructions that I received from the state entitled penalty phase jury instructions. And also printed out somewhere, although they're also online, the decision of the Florida Supreme Court on May 24, 2018, located at 43 Florida Law Weekly S246, as well as 2018 Westlaw 2355298. I'll say that again if I said that too fast. 2018 Westlaw 2355298, in which the Supreme Court came out with its final jury instructions to be given during the penalty phase in capital cases. So it appears, and I looked through these last night, that the state did adopt the new instructions as well as the new verdict form model. But let's go through these at this point. They are a total of 11 pages. There's a few optional sections that we'll need some time to address later on, but let's start with the initial paragraphs. Starting with the first paragraph, is there any current objection from the defense? This is an introductory paragraph. And for the record, we are talking about 7.11
Yes, sir.
of the Florida Standard Jury Instructions.
No, Your Honor, that's good. Not for the first paragraph.
All right, the second paragraph talks about the jury's requirement that they unanimously determine the existence of the aggravating factors beyond a reasonable doubt. That's set forth by the state or alleged by the state, and that obviously is pursuant to Hurst v. Florida, United States Supreme Court decision. Is there any objection to that second paragraph?
No, Your Honor.
All right. Then the state sets forth its aggravating factors. It starts with the aggravating factors for count one. We do have two first-degree murder convictions in play here. The first one asserted by the state is conviction of another capital felony or felony involving use or threat of violence to another person. In this case, it's contemporaneous convictions, which the case law is obviously clear has been forever, that contemporaneous convictions for capital crimes or crimes involving violence to another person can be considered. Is there any objection to that instruction?
Yes, Judge, we maintain our objections that we previously filed with regard to this specific aggravating circumstance. We filed a separate pleading, and the court heard that pleading several months ago and denied the objection.
Remind me of what you filed, because a lot has transpired between now and then.
Well, Judge, for each of these five aggravating circumstances, the defendant filed objections based on constitutional grounds and applicability that these particular aggravating circumstances, including the final one, which would only move the aggravated stalking, which would only apply to the first count, that they're unconstitutionally vague, that they do not, that they're overly broad, and as we stated in those previous motions, it does not, these aggravating circumstances do not narrow the class of persons eligible for the death penalty from our perspective. We made those arguments previously in court, and the court did not enter in order to deny that.
I recall that now, that you're not objecting to the language necessarily. It's a broader objection.
Well, we have to, for the record, we do have to object wholeheartedly to the entirety of the aggravating factor. They have correctly cited the statute for aggravating factor, but we still must maintain our objections.
Okay, so that for the record. Let's go to aggravating factor number 2 for purposes of count 1, that the first-degree murder was committed while the defendant was engaged in the commission of a burglary, sometimes referred to as the felony murder aggravating factor. Same objection, Mr. Wood?
Yes, Your Honor.
Okay, any other objection?
Not other than previously stated.
Okay, so that for the record, overruled. The third aggravating factor asserted by the state pertaining to count 1 is the heinous, atrocious, and cruel aggravating factor, HAC as it's sometimes referred to. is the standard instruction. Is there any objection to that other than your objection that you stated, Mr. Wood?
No additional objections. We maintain our objection previously stated.
All right. And then aggravating factor number 4, stated by the state is a cold calculator premeditated aggravating factor, otherwise referred to as CCP. And any objections to it other than your previous objections?
None other than previously stated on the record.
And you also wanted to maybe address different definition of premeditation that you're going to file at a later time.
Yes, sir. We'll have that filed by the end of the day, but it is the same requested definition of premeditation that we had previously requested for the guilt phase as far as the first degree premeditated murder definition.
And aggravating factor number 5 for count 1, asserted by the state, is that the first degree murder was committed by a person subject to a domestic violence injunction issued by a Florida judge, and the victim of the first degree murder was the person who obtained the injunction. Same objection, Mr. Wood?
Yes, Your Honor.
Okay. And we'll overrule all those objections as it pertains to 1 through 5 of the aggravating factors. Let's talk about the aggravating factors for count 2. There are 4 set forth by the state. Number 1, again, is the contemporaneous capital felony or violent felony conviction. Number 2 is that the first degree murder was committed while the defendant was engaged in the commission of burglary. Number 3 is HAC, heinous, atrocious, and cruel, or cruel. Number 4 is CCP, cold calculated and premeditated. Do you have the same objections, Mr.
We do, Your Honor, to each one.
So noted, and I'll overrule those. Then we get into, on page 4, the victim impact instruction. That's in the middle of the page. And any objection to that, Mr. Wood?
Judge, we had previously filed motions regarding the admissibility of victim impact testimony. The court had heard our motions on that and entered order denying those motions, specifically the victim impact. So we maintain our objection on that issue. I will update the court. It's been represented to me this morning from Mr. Johnson that they alluded to this as well, that there will be some letters that they will be introducing, which we still maintain our objection to the admissibility of victim impact, but they have promised to provide copies of those letters, and I raise that because one of the motions that we filed previously was to be able to see and review and have submitted to the defense what the victim impact evidence would be. And if it's to be only in written form and that's turned over to the defense, that would cure that issue, didn't cure the objection of victim impact, but it does allow us to see if the letters conform to the requirements of for victim impact evidence.
And I want to address victim impact separately once we finish with these instructions, because that's an area that we obviously need to talk a little bit about before we get into the penalty phase. All right, let's go on with the instructions. The next instruction, continuing on page 4 through the top of page 5, talks about that it's the state's burden to prove the existence of an aggravating factor beyond a reasonable doubt. It defines reasonable doubt as it pertains to aggravating factors, and then it goes on the top of page 5 through the second paragraph and explains to the jury that the aggravating factors must be found to exist beyond a reasonable doubt unanimously, and if they're not found to exist unanimously, they don't exist, or they're not found to exist. So any objection to those instructions, Mr. Wood?
Judge, as you see in my objections that I did file, we are requesting some additional language. It's in underlined form. It's solely in the one paragraph that reads a finding that an aggravating factor exists must be unanimous. That is, all of you must agree to that each presented aggravating factor exists. We had some additional language that we were requesting in there with regard to clarifications and emphasis to make sure that how they're to deal with aggravated circumstances, that they have to be that they cannot consider an aggravating circumstance that's not found to be proven beyond a reasonable doubt.
I'm looking at the underlying language in your objections or requested additional instructions. And I'll read it into the record. If more than one aggravating factor has been alleged, you should consider each aggravating factor separately and reach a separate finding as to the existence of each distinct factor alleged. Is that the language you're talking about?
Yes, sir, and then the second sentence, you may not consider any aggravating factor that was not found to be proven beyond a reasonable doubt. It's clarification language for our purposes, Judge. We just want to make sure the jury succinctly understands how to deal with aggravating factors.
Also, preliminary instructions, I apologize. At this point, I'm not going to give the additional language. Again, I'll revisit it during the final instructions, but again, my intention is to give that probably by the Florida Supreme Court. All right, and it has, for the rest of page 5, the discussion with the jury that if they don't find one or more aggravating factors beyond a reasonable doubt, I'm saying it backwards, if they do unanimously find one or more aggravating factor beyond a reasonable doubt, then the defendant is eligible for the death penalty, but there are additional findings that must be made. And the next one then talks about mitigating circumstances. And how mitigating circumstances do not need to be proved beyond a reasonable doubt, only by the greater weight of the evidence, and does not need to be unanimous. So any objections through the rest of page 5?
Judge, in that same paragraph that it would be the second paragraph below mitigating circumstances, at the very end of that paragraph, we're requesting the additional language. In other words, the jury is entitled to consider any mitigating circumstance, and the consideration of a mitigating circumstance does not require unanimity by the jury. And then, actually, if you, just for the record, too, below that, says we, among the mitigating circumstances you may consider, and then we have are requested, but are not limited to. That's in line with the, and what we in the profession talk about the statutory mitigating circumstance. That's, you can consider anything about the defendant's background, and et cetera. We want to make sure that that's emphasized to the jury, that there may be things that they have seen and heard during the course of the presentation of the penalty phase, or even in the guilt phase, that may be considered mitigating for them, but are not necessarily listed for them. And they're entitled to do that under the standard jury instructions. So we wanted to make sure that that, again, is emphasized for the jury.
I think that's currently adequately covered in mitigating circumstances number 23, but it's so noted for the record, and we'll get to all those in just a moment. Then we have a list of mitigating circumstances. There are 23 listed, 22 of which are more specific. 23 is the catch-all that you just mentioned.
Yes.
You can consider anything in his character, background, or life. Did you go through this, and does anything appear to be missing at this point? I understand there may be more that comes out during the
Not at this point. What the state has obviously done, we filed a separate pleading on requested mitigating circumstances, and they looks like they've cut based into that. It's almost inevitable that there'll be some revisions, additions, that sort of thing, as we go through the penalty phase evidence, or something may stand out that, and be worded differently than what's currently stated in there. So I guess at this point I can say for the record that the proposed mitigating circumstances as they currently exist in the state's requested jury instructions are consistent with that of the mitigating circumstances that we provided previously in a separate pleading.
I see one typograph where on number 13, the word love should read loves. So,
Okay.
I noticed you looked at me, Judge.
That was my fault.
Actually, I'm looking at both of you, so.
I thought it was amazing that, all four of us, 5 of us, in the jury instruction, we read, and still there was some stuff.
Yeah.
There's so much there, and you go over it so many times that it's inevitable something will get missed. Even in cases with shorter jury instructions,
Sure.
things get missed. And I try to pick them up on the fly, but sometimes you're just so reliably reading them that it's hard to pick them up. So
A lot of cutting and pasting that goes on too.
Yeah,
Yeah.
It's already fixed.
thank you. All right, then on page 7 of 11, talks about the jury weighing the aggravating factors versus the mitigating circumstances. Any objection to that one?
No.
Okay.
No.
Then on page 8, talks about the first paragraph, talks about the jury making a determination as to what it believes to be the appropriate sentence. Any objection to that?
No.
Next two paragraphs talk about the voting process for purposes of determining an appropriate sentence. Any objections to that?
No.
All right, then we go into weighing of the evidence. And any objection to any of those? It goes through the middle of 9. Any objection to any of those, Mr. Wood?
Judge,
I left in the money 6 because of the experts.
mhm.
And then I left in 7, just, I mean, obviously we don't know if that will occur, but the inconsistent statement.
I don't find much of that from penalty phase, but
Right.
it does happen.
Yeah, well, I guess we'll just have to wait and see. We'll obviously be readdressing these at the appropriate time.
Then we go into defendant testifying versus defendant not testifying. Obviously, we don't know what's going to happen at this point, unless a decision has been made at this point.
No, we're going to continue our discussions.
I didn't think one had been. And we have general rules for deliberation from that point on. Any objection from that point on? Mr.
No, no, Your Honor, I don't have any objections beyond that.
Let's talk about the verdict form. There was a significant change by the Supreme Court at the end of May as pertaining to Section C as well as Section E. Section C now no longer asks the jury to specify which mitigating circumstances were found to exist, and then doesn't ask for their vote. Section C now merely reads, one or more individual jurors find that one or more mitigating circumstances was established by a greater weight of the evidence, yes or no. Section E has a major change since May, where it no longer asks for the jury's vote if there was anything less than a unanimous death determination. So any objections to the verdict form, Mr. Wood?
Judge, we had a very brief discussion about this, and then we'll address it again at the end of penalty phase. But as the court is aware, in the May 24th opinion before Supreme Court, Justice Periente, in a concurring opinion, basically advised defense attorneys and the courts to consider and request in verdict forms that that the jury tally their vote as to each individual mitigating circumstance. And Justice Periente said that in order for the court to be able on its own to weigh the mitigating circumstances and findings by the jury, that such a polling and finding on the verdict form would be very helpful. We're going to request that. I'll put it in writing in a separate pleading for that judge. That's one issue. The other issue you addressed previously when we filed a separate pleading asked that the jury not be instructed that they have to be unanimous in order to find the death, in order for there to be a verdict for the death penalty. That's addressed in the verdict form as well, and we'll put that into a separate requested verdict form as well.
With regards to the mitigating circumstances, when the Supreme Court came out with their decision in May, changing Section C, I reached out and spoke with a judge from another circuit who's on the Hamlin Capital Cases Committee and was actually mentioned in that opinion. I was advised that actually the Public Defenders Association also asked for this change, oddly enough, and that they asked for that recommendation, and that was accepted recommendation. So I found that interesting. But again, it is my intention to follow what the Florida Supreme Court has directed that I follow in their majority opinion. But I'll entertain anything later on. That's fine.
Yes, sir.
Same thing with regards to count 2 is just one less aggravating factor on count 2's verdict forms. There are 4 aggravating factors set forth there as opposed to 5 on count 1. All right, let's talk about victim impact. How many do you anticipate for each decedent?
Well, 2, Your Honor. I think it's what we had agreed to before when we discussed this on basis of motions that were filed.
Okay, and the written statements, who are you going to have read the written statements? Is it going to be a relative, or is it going to be your victim advocate?
I think the ones that we've received so far, and Ms. Dutton can correct me if I'm mistaken here, but I think the ones that we've received so far, the individuals who wrote the statements will read them. And we've received, I think, 3 of the 4 so far. Is that correct?
Yeah, they've been coming in as we've been in here this morning, Judge. Miss Dobbins' father wrote one, and I had heard he wasn't going to be back, so I've inquired as to who was going to read that. It may be Lindy's husband's going to read one, and it may be that Lindy's husband's going to read the other one, but I'm still trying to figure that out.
The only additions to these statements, when these folks are reading the statements, is that they should obviously identify themselves and identify what their relation was to the decedent, but they shouldn't be deviating off the written word. Once you get the written, Mr. Wood, once you get the written victim impact statements, obviously we'll all need to go through them, see if there's anything that's objectionable in there. Obviously, we all know they can't make statements of recommendation and sentence, but they can talk about how the crime affected them.
One of the ones we received this morning, we're going to have to go back and do some edits, and we may do that before. But we've asked everybody to be sure you get your statements to us today, so there's enough time for everybody to review it. So.
Okay, very well. And then we can take some time. Usually it doesn't take very long to go through those because the state does a good job of editing out what needs to be edited out. But if there's anything that's in contention, I'll be glad to entertain that when we get there. All right.
Judge, just before we move on to the next topic, and just my own personal way to deal with this, and I think for appellate reasons, I think it's incumbent as we're going through victim impact letters or presentations to both individually and contemporaneously tender our objection. Obviously, there's a certain decorum that'll be maintained in doing that. I just wanted the court to be aware we're obligated to do that and why.
I obviously understand. I mean, that's been a hot topic, victim impact statements during penalty phase. And although the United States Supreme Court as well as the Florida Supreme Court said that it can at least be introduced to the jury, but I understand you need to protect that objection. You never know where the law's going to go.
Yes, sir.
All right, what do y'all want to take up next?
You want to deal with, let's do with the sequestration of the experts.
Okay.
This is a state's motion, really.
Is there an objection to it?
Yes, Judge, and just so, add a little, I guess, a little bit more specificity to the motion itself. As the court already knows, we've laid out the fact that we're going to have 3 witnesses, mental health experts testify, 2 of which are Dr. Mills and Dr. Buffington. Dr. Mills is 2 of those are going to be specifically on the issues of Mr. Colley's medication, Ambien, et cetera, that were ingested prior to the homicides in the case. Dr. Quiroga is going to be testifying on separate matters to do with mitigation. That's why she was never listed for the involuntary intoxication offense witness list. It's my understanding that from reading this motion, the state's motion, that they would like to have their doctors, I don't know if it's all 3 or 1 or however, sit in the courtroom and listen to the testimony of our mental health experts as preparation, I guess, for their testimony. Our concern with that, I know there's case law that deals with this issue. Our concern about that, Judge, is really twofold. At this juncture, all of the five of the six mental health experts, because we have 3 and 3 on each side, have been deposed. We're going to be deposing Dr. Meadows on Sunday. Point being is that each of the doctors has all of the witness statements, the discovery, medical records, pharmacy records, testing records, and they're fully aware of the evidence in this case. We've received transcripts from most of the doctors. I know they've been provided to the experts. So I don't, I object of the need to have any of these states' experts sitting in the courtroom as our experts testify. My other concern is that when they're sitting in the courtroom while we present our case, and then they subsequently testify, and again, I don't know if it's 3 or 2 or 1, in my opinion, that can be perceived by the jury as, for those individuals, state's witnesses, to have added weight to their testimony. It's unfair to the defendant for the state to be allowed to do that, and we simply see no need for that. So we do object to that, and I'll let Mr. Johnson speak to how many witnesses they intend to have exempted from the rule of sequestration.
You were complaining about their fees, and then you want to say.
Well, that may prevent us from being able to do it with everybody. I filed a motion to have the option of doing it. I doubt very seriously we're going to do it with everybody, Judge. But as I stated in my motion, obviously one of the reasons why this is oftentimes allowed is because the experts are experts for a reason, and we are not experts in their field. And so a lot of times they use language and the process that they go through to reach those conclusions are a bit of a mystery to us. That's why they're allowed to give opinions, is because they're experts in a field that's not part of the common knowledge. And so I know Mr. Wood's argument first was that they pretty much have everything, and we try to do a good job in terms of taking their depositions, but inevitably there are things that come up during the trial, that because we're not experts, we don't think to ask, that we learn about during the course of the trial. And so having an expert here to assist us in understanding the particular testifying experts, what they're testifying to, and areas that we may want to ask them questions about, or areas of disagreement, they can bring those matters to our attention. And so this is not like a lay witness where there's some danger of somebody changing their testimony after hearing another witness testify. This has to do primarily with the fact that these experts are testifying in areas that we're not, really super familiar with. Even though we've been doing this a long time, there's some things that we can anticipate. I don't think we can anticipate everything. This actually is a relatively new topic for me, so particularly as it relates to the issue of intoxication and prescription medications and the effect that they have on individuals, how the effects that they may have had on this particular individual, what he told these doctors, and so that's why we're asking to have that option for the experts to sit, listen to the other experts' testimony, and advise us accordingly.
There's a body of case law out there that generally exempts expert witnesses from the rule of witness sequestration. A lot of that case law addresses the fact that witnesses can't premise their opinions based upon the testimony of other folks. In this case, I don't find that there's unfair prejudice to the defendant in allowing the state's experts to sit in and potentially assist the state with dealing with some of these expert areas, particularly because they have been deposed or will have been deposed by the time we get to the penalty phase next week. That way, there's little risk of them changing their opinions and changing the foundation for their opinions. Should they do that, they would be subject to obviously strenuous cross-examination by the defense if that should happen. So I am going to allow the experts for both sides to sit in during the course of the trial or the penalty phase and exempt them from the rule of witness sequestration.
And if there is any material change, obviously, we will make the defense immediately aware of that, so.
Sure. Judge, we filed what we titled Defendant's Third Motion in Limine. This has to do with, and actually, let me kind of go back. You may recall, I know it seems like probably an eternity ago, but the state had back on June 25th filed a notice of evidence they want to seek in rebuttal. We filed a response to that. Again, the defense of involuntary intoxication was on the table at that particular time. State wanted to conceivably open the call in rebuttal witness. And your Honor's response when we discussed that motion was that you really couldn't rule on that until such time as we get to the point of rebuttal. When the state filed their renewed or amended motion dealing with that, we wanted to certainly have the appropriate response as well. I guess the only thing that we wanted to make sure the record is clear about, or just at least put the court on notice of, is that we're concerned that the state may try to elicit these very same items, and there's 4 that are listed in there, in cross-examination, in either cross-examination of our mental health experts or in the direct testimony of their experts. It's conceivable, just because I've been doing this so long, obviously rebuttal witnesses can be separated apart from those witnesses, but I just wanted to make sure that the argument at this point is rounded out, that I would request that if the state were to want to get into the items that are listed here, that matter be proffered or dealt with outside the presence of the jury first, so that the court can make a ruling of admissibility, so that we don't have or that we can clear up that issue as far as the penalty-based process is concerned.
I think the request for proffer is fair, but let me ask the state, do you intend to go into any of these if the door is not open, or at least you believe the door's open?
You're obviously the gatekeeper of the door, Judge, obviously. So, and I don't necessarily have a disagreement with proffering that. But if the door is opened, obviously, these are questions that we believe are admissible, and would be areas that we may want to get into. So it all depends on the testimony considering the intoxication. I guess it's not a defense at this point, it's more mitigation evidence, depending on what that evidence is and how it's presented, and how this information has been provided to our doctors. Our doctors felt that this was information worth considering in issuing their opinions. Mr. Wood has had an opportunity to take their deposition concerning that, and they've given him answers concerning that. So again, we have to, I guess, wait and see how the evidence develops. We certainly anticipate it will develop that way, but we're more than happy to proffer that before it's presented to the jury.
Experts can consider a lot of things, but it doesn't mean they can testify to those things during the trial,
Right.
or penalty phase in this case. So I will defer ruling on it. I'll take it under advisement. If the state intends to elicit any evidence pertaining to these 4 distinct events or topics mentioned in the motion, I would ask that the state proffer it, or at a minimum approach sidebar or outside the presence of the jury, so we can discuss it and make a determination at that time based upon the evidence and testimony that I've heard to determine whether that evidence or those topics would be admissible.
Judge, following that would be the defendant's 4th motion in limine. Again, this is directed to penalty phase, and it deals with the issue of that sometimes can creep into a death penalty proceeding, which is the what we all call future dangerousness argument, and that can come in. I know I'm sure I've dealt with this on your prior cases, where there is some testimony, some alluding of, it can come through cross-examination, or I guess through direct testimony from a state's witness about the concerns that the defendant is likely to kill again or harm others in the future, those sort of things. I don't know if that's ever going to come out.
It's not.
But it's, and as you well know, we deal with motions in limine not because we hopefully don't know what we're doing. It's just to warn witnesses and say, hey, you got to stay away from this. And if we haven't made the motion, haven't made the request, then I do not want to consider that waived under any circumstance.
I have unfortunately seen that door blown wide open on this sometimes, but I don't anticipate that here. We're very good seasoned attorneys. Okay. So if you don't anticipate, go ahead.
No, Your Honor, we will instruct the
By
witnesses.
stipulation, I will grant that motion.
And Judge, the state had filed a motion in limine regarding character evidence of the victims. Judge, we simply put, because of how penalty phase is structured and what the law requires in terms of presentation, I don't anticipate this will be an issue. We'll do everything humanly possible, have done everything we can, and will continue to do so to avoid this as being an issue. Our focus completely now is on Mr. Colley and presenting mitigating evidence, and hopefully arguing successfully to the jury about a sentence for him in both counts. So I don't have an objection to this. Again, we'll do everything we can to make sure this does not become an issue.
I'll grant this motion by stipulation. That is stipulation regarding character evidence of the
Yes, sure. Judge, the state has filed a motion, but it did in the guilt phase, and it renewed it again with regard to Dr. Buffington's testimony.
trying to locate some of the materials.
I also yesterday filed did a notice of filing which included Dr. Buffington's CV.
50-something pages long, I think.
Yes, sir.
A lot to it.
Yes, sir. And if need be, Judge, I can certainly provide the court with a copy of his deposition transcript.
It was somewhere in the materials. I came across it when looking at this issue as related to the guilt phase. Maybe it was filed.
Yes, sir. The state had filed the motion, and then when the issue of involuntary intoxication did not come to fruition in the guilt phase, and when we represented to the state that we were going to still call Dr. Buffington in the penalty phase, then the state, Mr. Johnson told me as much, that he was going to be filing an amended response, or amended motion in limine regarding Dr. Buffington's ability to, in scope of his testimony.
I've read the motion. I feel like I read it twice now, that it's refiled in the penalty phase. Where the state's position is that Dr. Buffington, having a doctorate of pharmacology as opposed to a PhD in psychology or being a clinician in some other discipline, would not be qualified to render opinions as to how these medications specifically affected this defendant, as opposed to, I guess there's no objection to him testifying, I don't want the words in your mouth, no objection to him testifying generally as to what these medications can do, or the cocktail of medications can do. But am I summarizing that correctly?
No, I think that's spot on, Judge.
Okay. All right, is there anything you want to add to that?
Not really, Judge. I mean, I do have some case law. It's not like completely on point, but it's in response to Mr. Wood had cited a case in his response, which I believe was the DeSerio case, and which has been red flagged. And so I kind of tracked the history on that case. There was kind of some back and forth with the 4th District Court of Appeals, where they said that a neuropsychologist in that particular case, a completely different issue. The issue was whether or not a neuropsychologist could testify to the medical cause of a child's brain damage that was suffered at birth or while in utero. And initially they said that...
Probably a civil case, because it comes up all the time in civil cases.
Right. And so it said that he couldn't, and then it said, and then another case came out that said that he could, and eventually the matter was resolved in the Grenett case, which I provided to the courts, a Florida Supreme Court case, The citation is 858 Southern 2nd, 999. Was decided in 2003. Essentially, they said that no, a neuropsychologist could not testify to the medical cause of brain damage.
But
So
they can testify to the existence of brain damage.
they can, yes, sir. That is correct. I provided this as close as I could find to a case kind of on point, Judge, and so I provided that because it appears to have a little bit of a different holding than the DeSerio case that the defense has cited in their response to our motion. So it's our opinion, just as you said, Judge, Dr. Buffington, we agree, is well qualified to testify about the chemical composition of drugs, their known side effects. I think the issue here is whether or not he can testify that this particular defendant on this particular day suffered those particular side effects, and therefore he could not form an intent or had a lesser intent, so to speak, since this is a mitigation issue on this particular. I think Dr. Mills is perfectly well qualified. We deposed him. He's a psychiatrist. He's been practicing medicine for 30 years, maybe longer. We have no issue with his qualifications on the issue, which I think also addresses the overlap here. I think there's a cumulative issue where you're going to have two experts essentially testifying to the same thing, and we think it's best if each of the experts kind of stay in their lane.
Mr. Wood.
Well, and as far as the lanes are concerned, and I know the court would not know this, Dr. Mills has received both the deposition transcripts from Dr. Buffington and PowerPoint presentations or slides that was provided through depositions of Dr. Buffington that goes through not only the adverse side effects of the medication Mr. Colley was on, but also too talks about the impairment and impact on the day of the homicides, August 27, 2015, that those medications or the adverse side effects of those medications would have had on the defendant at the time of the commission of the homicides. Dr. Buffington certainly is, as you see from this TV, well qualified certainly to talk about adverse side effects of those medications, but he's also qualified to talk about what we're going to be getting into in the penalty phase, which is impairment due to the adverse side effects, impairment at the time of the homicides due to the adverse side effects of particularly Ambien, but also the other medications that he was on, how they would have impacted him based on the timing of the intake of Ambien and the other medications, how they would have impacted and impaired him at the time of the offense. So we've gone from the potential of having Dr. Buffington testify specifically in addition to the adverse side effects of these medications. In guilt phase, we had lined him up to testify, and he would have testified to issues with regard to involuntary intoxication and intent to commit the crime, a specific intent crime, that being first-degree murder and or burglary. However, the issue in penalty phase is impairment, and we've listed that as a statutory mitigator and a non-statutory mitigator, with the first being substantial impairment, the other being impairment on either of those two fronts. So, Judge, Dr. Buffington is, as you see from the CV, has a tremendously well-documented, thorough background. He teaches at the College of Medicine for the University of South Florida.
He's not just a pharmacist at CVS.
He's just not, yes.
He's a farm back and forth in your
Yes, yes, sir. And he has said in his deposition, and again, I'll be glad to file for the court, he's testified over 250 times. I've cited in my motion that we've been provided, even back in 2013, a list of over 100 cases that he's testified. Just since 2013, there's a federal rule requires that experts that testify in federal cases maintain a log of their trials. So, and I've cited in a footnote of my response some bad feedback about a couple of cases, particularly that Dr. Buffington has elicited testimony on that I was able to find transcripts to about mental state, the Callis case, K-A-L-I-S-Z, v. State, 124 Southern 3rd, 185, where Dr. Buffington provided testimony, and I didn't see anywhere in the docket or the transcripts where that was objected to as far as qualifications, to give testimony about the ingestion of medications and the impact on the defendant to voluntarily waive his Miranda rights. He's also testified in mental state in the Richter case, which is actually currently still pending in post-conviction status. The direct appeal, the Florida Supreme Court rendered their direct appeal decision in 193 Southern 3rd, 846. He teaches at the college, but he teaches other doctors about issues about medicine, about medications rather, and adverse side effects, makes recommendations to doctors about the appropriate medication concerning the health of the particular patient. He's a clinician, which means he's not like Dr. Goldberger is a toxicologist that doesn't see patients. He sees patients. And he has specifically interviewed this defendant, as has our other doctors, including Dr. Mills. He does have a Pharm D degree, which is the highest level for pharmacology. He is allowed to advise doctors on issues of medication. And I know that in the state's motion to eliminate, they cite it's 465.03 subparen 13 on the definition of practice of the profession of pharmacy. The state has focused on one part of that definition as a basis to exclude Dr. Buffington's testimony. However, in the under that subsection, practice of professional pharmacy includes compounding, dispensing, and consulting concerning contents, therapeutic values, and uses of any medicinal drug, consulting concerning therapeutic values and interactions of patient or proprietary preparations. It goes on further in the middle of that, it's about 7 lines down. Other pharmaceutical services means the monitoring of the patient's drug therapy and assisting the patient in the management of his or her drug therapy. And then further down, the practice of professional pharmacy also includes any other act, service, operation, research, or transaction incidental to or forming a part of any of the foregoing acts requiring, involving, or employing the science of or art of any branch of the pharmaceutical profession, study, or training, and shall expressly permit a pharmacist to transmit information from that person authorized to prescribe medicinal drugs to their patients. So I think the state, as I've said in my response, is focusing on the label in this particular situation as a basis to limit his testimony. It has to do more with the weight. I cite the Smith case, Smith v. State, Southern 3rd, 473, a Florida Supreme Court case from 2009, that dealt with, in that particular case, a very interesting case actually, where apparently there was some wiretap recorded conversations of a drug transaction, and it was all in code. And in that particular case, the Florida Supreme Court upheld the trial court's decision that a detective who was determined to be qualified as an expert in drug code language was allowed to testify as to his interpretation and meaning of the recorded conversation concerning the drug transactions. And that's a lot of what we're dealing with here. In order for Dr. Buffington to really put his testimony about adverse side effects into full context, he's aware of the allegations, he's received police reports, he's interviewed the defendant, he knows about this case, the background and the allegations. And he can testify that the defendant was substantially impaired due to Ambien and his other medications from his intake of Ambien at 5 o'clock in the morning and being woken up a couple hours later. And then what Mr. Colley was experiencing at the time of the homicides themselves. Again, Dr. Mills has, in his opinion, has also considered Dr. Buffington's presentation and slides and testimony, and is able to testify certainly about impairment as well. But we would like to be able to call both doctors. It's not cumulative because both have different backgrounds. Dr. Buffington, certainly the expert with regard to the effects of the various medications, is a complete background on that, but also his evaluation of Mr. Colley's impairment, that has informed Dr. Mills on certain issues with regard to impairment that he's going to testify to. So we would ask the judge, the court, deny the state's motion in limine because I think it really has to do with weight, not admissibility.
State, want to hear any further?
Yeah, just real briefly, I know Mr. Wood mentioned the Colley's case and made the argument that there was no objection to Dr. Buffington's testimony in that particular case. Of course, there's a variety of reasons why somebody may not have objected. I do know that in the Enoch Hall case, which is a Daytona case back in 2009, who now Judge Leah Case prosecuted, she did file the exact same objection to Dr. Buffington's testimony.
During the guilt phase or the penalty phase?
During, I believe it was the
Guilt phase.
It was the guilt phase because it had to do with ibuprofen and Tegretol. And so the same objection was filed. I actually tried to get onto CCIS to try to, and I couldn't find a lot of these things, but my motion was based off of hers. So I'll admit to a little plagiarism there.
I'll let it
So, and my understanding was the judge there limited. Now, unfortunately, for some reason, that didn't get addressed on appeal. So unfortunately, I have no precedent on point. But in terms of objections, I know at least in one case it was objected to, and the judge did limit his testimony. Unfortunately, it just wasn't addressed on appeal, so we don't know how that would have played out. So.
Can I address it real quick?
Yeah, go ahead.
Because I have read the transcripts on that. The Enoch Hall case, and for the record, Enoch is E-N-O-C-H. And in the trial transcripts, which were part of the record on appeal, Mr. Hall was an inmate. And if I understand the facts correctly, Mr. Hall was accused of and was convicted of killing a detention officer, a correctional officer, there at the jail, a female. And the issue in the Hall case was that was whether or not Mr. Hall, who had filed an involuntary intoxication defense, could go forward with that defense on the adverse side effects of Tegretol. And the court ruled in that case that testimony regarding the effects of Tegretol were inadmissible, irrelevant, because as it turns out, and this is in the instructions for involuntary intoxication, Mr. Hall never had a prescription for Tegretol. So it didn't go any further than that. I'll be glad I've got them on my computer. I can send you the transcripts. I'll be glad to send Mr. Johnson that as well, too, that the court never made a ruling as to the admissibility of Dr. Buffington's testimony or the scope of his ability to testify. It was because he couldn't get out the gate with the involuntary intoxication defense because he never had a prescription.
I do know he was allowed to testify. I mean,
He did. He
yeah.
testified.
Because the opinions actually cite his name and what he was allowed to testify to.
Yes,
so.
sir.
You can't even more than enough to read in this case, and I'll be reading transcripts from another case. These are this is a unique issue that I don't know if it comes up much across the United States, but there sure are not many appellate opinions on it. When this issue was coming up in the guilt phase in this case, which we never had to address because the involuntary intoxication defense was abandoned, I did spend several hours on Westlaw just to see what I could find on this, and I found two cases out of state in which it was not a subject of the appeal, but it did mention in the opinion that a pharmacologist was permitted to render opinions with regards to involuntary intoxication. One is People v. Smith, located at 231 Illinois Appellate 3rd, 584, from the First District Court of Appeal of Illinois in 1992. And testified, and he opined that the defendant was involuntarily intoxicated at the time and would have been drugged at the time of the offense. So there's a blurb on it. It was not a subject of the appeal itself. The court didn't go into whether that was appropriate or not. There is another case out there that I found, State of Arizona versus Armbruster. It's not reported in any of the West reporters, but it is reported at 2011 Westlaw 2937202. It is from the Arizona Division 1 Department E Court of Appeals in 2011. And there, Dr. French, a pharmacology professor, testified that the defendant experienced some rare paradoxical reaction to lorazepam, which caused him to become aggressive and hostile. So there's two opinions. And again, that was not the subject of the appeal. They just go through some of the background of the case and mention that in there. I am going to allow Dr. Buffington to render opinions with regards to the defendant's impairment. He is not merely a pharmacist, but a pharmacologist with a doctorate in pharmacology. It is something that pharmacologists look at, not only the effect of medications on human beings in general, but the effect of medications on particular human beings and how combinations of medications may affect them. So I am going to deny the state's motion of eliminating as it pertains to Dr. Buffington.
Thank you, Your Honor.
To that penalty phase with regards to impairment. What's next?
I think that's it, Judge. I don't know anything else right now.
Are there going to be more filed over the weekend? I hope not.
Only if I take my laptop home.
Someone needs to keep your laptop on you. Do that.
I think I'm good for now, but
You are going to file that, you mentioned the...
yes, I'll get that done by the end of this
presentation, post instruction on that.
Can I also do, I may not get it in before Monday, but at some point I'll file the requested verdict form regarding the mitigation circumstances.
All right, 8:45, we'll have the jury back. As soon as we have the jury gathered up, we'll get them in here. I'll cover that preliminary matter with regards to the additional polling, and then I'll give them the preliminary instructions, and then opening statements, and then begin the testimony. Okay.
Thank you, Judge.
We can see you all.